Go. Actually share sometimes financial documents.
One thing good about the story first was they were still able to I called. So, supposed to do like every 2 or 3 years. Yeah, okay. So, yeah, so that's what I ended up doing. Amazon. Well, this came, it was the generic version of the one that was built by. Stay right, built by. But I said, well, I'll save money, like under 95. For the same thing. So, what's this? We have to go and never, ever, and then I find when I got back out, I too small. I bet you had the old. Yeah. And then, so I pulled it out. Yeah. So anyway, this is why I think you can say that what you do is you go online and what return they're small and get a thing you print it out and it has and it all reset. Taking out like 100 degrees. That's it. I had to take.
Good evening. How's everybody doing tonight? We've got a great program for you. Before we get started, I want to make sure that the microphone is working correctly and make sure that everybody can hear me.
Good.
And also, because we're doing some recording, I want to make sure that the authorities in the back also are able to take the recording. It's going to be what they need. Is this going to be about right? Okay. Anyway. My name is Mike Vernon, and I'm delighted to welcome you to our February edition of the Florida Lecture Series produced by the Walton Chimes Center for Florida History. I'm especially pleased to announce that tonight's program is the Robert and Rose Stahl Criminal Justice Lecture, which honors the memory of Robert and Rose Stahl. Mr. Stahl served more than 30 years as a police officer, including his years as chief of the police in North Miami Beach. The family of Robert and Rose Stahl has generously made this annual lecture available to Florida Southern College in our series over the years. And I'd like to recognize Larry Stahl, if he's here tonight. I'm not sure if he's here. I tried to remind him about tonight. If you're here, Larry, please be recognized. Now I want to thank those of you who supported us this year with your attendance and financial support. Before I introduce our special guest tonight, I want to tell you about a few things we have in store. I'm sure many of you have noticed that our last scheduled program for the year is April 2nd, when we will welcome Florida environmentalist Hillary Swain to our stage. She is an incredibly knowledgeable and national voice on the Florida environment. But I'm excited tonight to be able to report 2 additional events that you'll want to put on your schedule for March. On March 12th, we'll welcome back Bob Keeling and musician and WMNF radio host, Reverend Billy Works, for a screening of their new film, The Florida Chitlin Circuit, a 45-minute documentary exploring Florida's vibrant mid-20th century circuit for Black entertainers. Through interviews and rhythm and blues legends, the film offers stories from those who lived and loved the series, and music and Q&A will follow after the screening, and that will be right across the way over there in Branston 202 in the theater over there. We have flyers out there, and I encourage you to pick one and get one and join us on March 12th. We have another event for March that we're planning as well, so stay in touch for updates. Now I'm delighted to introduce you to our special guest tonight, who will help us commemorate Black History Month here on campus. I was checking back before I wrote this, and this is the 3rd time that Professor Vernon Burton has been with us. Many of you will recall his 2011 program on Abraham Lincoln. Since that time, the popularity of his acclaimed book, The Age of Lincoln, which is available tonight, has grown over time and continues to inspire discussion and extensive readership. In fact, Vernon tells me that he received congratulatory letters from both Presidents George Bush and Barack Obama on the book when it came out, and my students are reading it now in one of my classes. In fact, my students are reading both of Vernon's books, which are up here tonight, and of course, they're out there, I'm sure, somewhere. My students are reading both of these books, and they agree with President Obama and President Bush that it's a beautiful, multi-layered saga of our nation in Lincoln's time. It's a beautiful, beautiful written book. But tonight's focus is on the Supreme Court. More importantly, Florida cases that have reached our nation's highest court. Professor Burton brings to tonight's program a profound understanding of the history of the Supreme Court gained through many years of research and writing of Justice Deferred, Race in the Supreme Court, published by Harvard University Press, which is available also tonight. The acclaim for the book has been universal. Heather Cox Richardson calls Justice Deferred a magisterial history, smart, accessible, and important. Civil War historian James McPherson notes that the book is a vivid narrative and analysis of social and political conflicts, whose issues made their way to the highest court for resolution. I could go on, but now we need to meet Professor Burton, and so now let's meet our special guest. Orville Vernon Burton is a country boy made good. Born in Boyston, Georgia, but reared in 96, South Carolina. Anybody know 96, South Carolina? Burton holds degrees from Vernon University and a PhD from Princeton. He is one of America's leading scholars of Southern history, but his life's work has been a multidisciplinary in approach. His research and teaching interests include race relations, family, community, politics, religion, and the intersection of humanities and social science. Burton taught at the University of Illinois for over 30 years, where he earned distinction as a teacher, scholar, and mentor of numerous graduate students. Burton has authored over 20 books and hundreds of articles. A recognized authority on race relations, Burton is often called upon as an expert witness in discrimination and voting rights cases throughout the United States. In 2010, he was named Judge Matthew J. Perry Distinguished Professor of History at Clemson, which is in the neighborhood of his old hometown, where he continued to maintain an impressive array of accomplishments, accolades, and leadership positions in national history circles. He has served as president of the Southern Historical Association and the president of the Agricultural History Society. In 2016, he received the Governor's Award for Lifetime Achievement in the Humanities from the South Carolina Humanities Council. And in 2001, he received the Southern Historical Association's John Hope Franklin Award, Lifetime Achievement Award. Burton has received fellowships from many institutions, including the National Endowment for Humanities and the Carnegie Foundation in the United States Department of Education and the National Park Service. Ladies and gentlemen, please join me in welcoming Dr. Vernon Burton to our stage.
I really appreciate Mike or Dr. Denham lowering expectations. I feel like coming here to talk about Florida history is like taking clothes to Newcastle. There's nobody that I know that knows as much history about Florida as Mike Denham. I know no one who's done more to advocate for and to get people interested in the important history of Florida. And there's no scholar or teacher I respect more for all the talents and things that he puts forward to do that. So thank you. It's always an honor to be here. I promised to do much more of what I was going to do until I got into, in fact, doing this lecture. I knew about 3 cases, and then with a book that came out that you had, it was a key here to speak. And the Groveland case was really not well known in the historical or in the literature of legal scholars until that book. I thought, well, we got 4 cases, we can do a lot of things with that. I started researching, and I found 16 cases, which is a lot more than we can cover. In fact, I had hoped to do a lot of things. I was going to talk about Florida and Southern history, and is Florida distinct or not. I thought it was important that to define what race is. I still do, so we'll have to do that. And look at these cases. Now, all of these cases do something that I think help us about Florida. It's what Mike had told me, and one of my MA students who worked with me, in fact, as a research assistant, particularly on the web things, on Justice Deferred, and that is the more you study Florida, the more you find, and the more you find that hasn't been done. And in my case, the more I found about, the more I saw that it was not only as looking at these legal cases suggest that, yes, it is Southern, but that also, in many ways, it's led the South in ways that we hadn't thought about. The Civil Rights Movement reminds me so much of South Carolina with this sort of idea that we're not like those rednecks down in Alabama and Louisiana and Mississippi. But it had one of the most important Florida did, Civil Rights Movement, as did South Carolina. It's interesting how the myth grows around these things. About the South, I'm always reminded that when I was in the Army in 68 and 69, I had a sergeant who had been 6 tours to Vietnam, was going on his 7th, and he was always telling us about how he loved to sort of frag, that is, shoot Yankees who were officers. When I was in ROTC a year ago, and he said to me, "Where are you from?" And I said to him, "South Carolina." And he said, "Well, you're blankety blank damn Yankee." And I hate Yankees. And I said, "Well, you know, Sergeant, I was born in Georgia." He said, "You're still a damn Yankee." And so finally I said, "What is it?" So he said, what does it take not to be a Southerner? He says everything north of Valdosta is a Yankee. But so I think it tells us about perspective that really, really matters in our history. We forget that sometimes. It's like I don't know why I was going to tell the story, but two presidents had to read my book, and both took the words, I said the same words and two different meanings from them. What you say is not always what happens. And Gilbert King reminded us, in fact, let's see, here we go. Sorry about that. Okay, there's our 16 cases, sort of in chronological order, but because the lecture series is on criminology, we'll deal with those first, and I'm afraid I won't do with all of them. I have asked Dr. Vernon to stop me at 40 minutes, even if I'm still doing this introduction. I love questions. I think that's the best way, and I want to hopefully give you more hurt my feelings. I know get somebody upset talking about the South and race relations from the South, or as I'm saying the South, and you learn, then I haven't done my job. I have 5 daughters. There's no way you can hurt my feelings. Little girls think their dad can walk in water until they're 12, 13. You know, they're necessarily doing the same thing that you can't swim. So please, I hope we'll have time for give and take. It's what I really like the most. Well, King wrote that in the 1940s, Georgia reported a high number of lynchings and registered more members of the Ku Klux Klan than any other state in the South. But because the South of the South, people have not really given much attention there. Well, I think it's interesting. My former MA in Cincinnati Boyd is working on a great dissertation at the University of Georgia on Florida, looking at things. And so he shared with me this as well, that racism, of course, we now know is not a uniquely Southern problem. But well before the United States, other places witnessed riots and public conflicts over school immigration and busing in places like Los Angeles and Boston in the 1970s, Florida was both a center of Northern American migration and racial violence. By 1920, Florida's population has the highest proportion of non-Southern, principally being from the Northeast and Midwest. And Dr. Little shared with me today, there was the Abraham Lincoln Brigade of the Ku Klux Klan in the 1920s. Here, figure that one out. Who largely settled in the peninsula where post-Civil War railroad development was greatest. From 1877 to 1950, Florida had the second highest rate of reported lynchings per capita in the United States, with Mississippi being the top spot. Well, the correlation was coincident. Most reported lynchings occurred in Central Florida. And this is a heat map from the Equal Justice Initiative in Montgomery, Alabama. And when historians have looked at individual race massacres in Florida, they've identified, in fact, northern migrants as participants, if not ringleaders, of some of those episodes. I won't go through them, but there's a lot of evidence for it. Now, you hear the word unprecedented a lot today about what is unprecedented, what we're going through at this time. The transfer of power from, in fact, John Adams to Thomas Jefferson was pretty much unprecedented. The Civil War and Reconstruction, extraordinarily unprecedented time. The Gilded Age, which was streams of wealth, the era of the Great Depression, but especially what I call the Long Reconstruction, which cannot be separated from the Civil War, really echo a lot of what is going on now, I think, today. Some of the parallels, it seems to me, that if we believe that there's some reasons to study history, which I think is critical, are clear. Then is now religious fanaticism strongly influenced the views. People who believe they know and do God's will are not likely to compromise. Whether on slavery, immigration, citizenship, voting rights, abortion, sexual behavior, jihad, contested elections, or crime prisons. Then in our own day, there was and is a great anxiety about a changing economy and extremes of wealth in today's second Gilded Age. Both eras brought also an intense fear of being left behind. Now, our era and the past brings us the importance, I think, of the Supreme Court as the arbiter of our rule of law, which is, I think, what has always made America different. Now, justices have legitimate interpretation of how narrow or broad a law should be. We do notice whether the rule of law applies to everyone or if a selective few. I really still have faith, though, and I honestly believe that evidence, and particularly young people, are the hope of the future of our republic and within a democratic society. We have been here before, and it is the rule of law and the use of evidence was safe as then, and which I believe will again redeem America. I just want to take, because this is one of the themes that, oops, I think I went too far here. There we go, sorry. I have to look back and I'm not used to looking back. I was always talking ahead. Evidence, if there's anything here, the centrality of evidence in a day in which I think we really need, again, to understand how important evidence is. Henry Adams, who was the son of Charles Francis Adams, who was ambassador to England during the Civil War, proclaimed in the Education of Henry Adams that the American mind stood alone in history for the ignorance of the past. And in this day of alternative facts, fake news, it's good to remember once again the sage advice of his great-grandfather, our second president, who along with his son John Quincy Adams, stood alone among the early presidents as an opponent of enslavement. Facts are important things, and whatever our wishes, our inclinations, or dictates of our passions, they cannot alter the state of facts and evidence. I really think it is critical to study history, the humanities, for a lot of reasons. I have too many long lectures to get it in here, but I often remind people I have worked at two great universities and I support STEM. I ran two computer centers where I work with science. I found them the best. They're the best. They have time to read the books. Humanities scholarly writings. They don't get chances of supporting the humanities not part of it. But I argue there are two things that changed the American South: air conditioning and the Civil Rights Act and Voting Rights Act of 64 and 65. And we as Americans, because we believe in STEM education, we understand the need for STEM education, but not the importance to democracy of what used to be, when I went to school, was called civics or history, but the use of evidence. In fact, one of the things I think that has happened that is why so many legislators in the South are saying you cannot teach certain subjects, might make people feel bad, is that our public school teachers have done such a fabulous job in the last 20 years in being honest and open and helping students to understand our history, that in fact there has been a backlash to it. It's not that it has been a failure, it's been that they have had a great success. I really believe that school teachers in the public school or any other schools literally are doing God's work. Now, one of the big issues that we look at, and we're not going to do the civil rights cases, we just don't have time. We'll come back to the 14th Amendment and its enforcement. And this is also how, in fact, the success of Reconstruction, which was so successful, and we look at it as a phase in the most progressive period, certainly in the South of our history, it was an incremental change. Not all at one time. It's not 1876 when supposedly the troops were withdrawn supporting the Republicans in the South. Reconstruction and the laws continued. One law, another law, and each one takes away until there is nothing else left. Now, I want to quickly talk about race and the definition of race as it will come back along. I don't know how well you can see this picture, but it's 1927 is the lung case. And after this, we won't talk about any cases much outside of Florida, defining them all. And in this case, if you look to the front row, right, the second, I don't know how to do the form, sorry about that. Let's see. There are two Chinese girls who had been going to school with the white children, built a new school, and then they decided that they could not go because they were not white. It was always Supreme Court. The Supreme Court says, yes, they are not white. They moved across the Mississippi River and went into Arkansas and became white again. But that is just, if you look at the picture, you can see there are other people in there, Italian, Native American, and others in Mississippi that was also cited a lot of. And that's sort of the point of trying to define what race is. We know race is a social construct today. There's no such thing as race, and I thought everyone still agreed with that until about a year ago. I was on NPR, and it's not supposed to be a debate. NPR has a program called The Middle that makes people from different perspectives, and it was a call and we told them not to debate each other. The other person was Andrew Sullivan, who I've got to know and actually like quite a bit. And he had, when he was the editor of the Republic, he had published a great deal of the bell curve, which argued their genetic differences, that particularly African American intellectual inferior. A lot of people almost resigned since published articles about it. And I just had to mention to him beforehand, that he didn't still believe that, of course. He said, well, yes, I do. And so I was sort of in shock. I said, I know we're not supposed to debate it, so help me if we go there. If you say that, then I'm going to have to disagree with you, and I promise that theologically, and I think intellectually, I will destroy you. So we did. We disagree. I bit my tongue on a lot of things he said. Blood was running out of my mouth, but we did not talk about race. But it really shook me up that we once again have people who really believe this, and very smart people. The American history race is still being written today, whether it's affirmative action or voting rights, criminal justice, and felony disenfranchisement. Florida has been central, in fact, to making and enforcing the laws, and the present grows out of the past, and I believe shapes our future. Now, cases, especially what's called the native of race relations, that period of time after the English construction, really began in the late 1890s, going quite for a Colosseum period. It's interesting to see how the Supreme Court struggled with trying to define race. Basically, they couldn't. I think it's worth thinking about it now a little bit. In 1790 Naturalization Act, only people who are white are defined as American citizens, have been set that way. And in fact, in 1857, this is our case, only whites can, be naturalized citizens. That's the law in 1870. And then you have the famous Judge Roger Toney decision in Dred Scott, where he said those hateful words that African Americans had no rights, which the white man is bound to respect. And for the first time in the history of our Constitution, he fastened race discrimination into it. It had never been there before. Now, in 1870, during Reconstruction, with the 14th Amendment, the 13th, 14th, and 15th Amendment, of course, 1870, they revised the Naturalization Act of 1796. African Americans can be a part of it. There are a number of other little amendments. So much so by the 1920s that a Mr. Ozawa, who was born in Japan, but he's lived in the United States a long time, he was a veteran of World War I fighting for the United States. He thought the new naturalization law was worded in a way that he would be white and he would be able to be a naturalized citizen. The case went all the way to the Supreme Court, who agreed the wording might be interpreted that way, but that clearly the meaning and the purpose of the law was such that white remained a requirement. And I did often did, like Tony did in the Dred Scott decision. They couldn't stop there. They said to say a little bit more. And so they said that white could not really be a color because, like the little picture we showed of the Chinese children, white people often had darker skin than non-white people. So the justice decided that what it really were, white meant Caucasian. And so Mr. Ozawa was not Caucasian because he was of Japanese descent. So he's not a U.S. citizen. The very next year, 1923, Mr. Stein, whose ancestry went back to the Caucasus Mountains when he killed Burton. In other words, he is a real Caucasian, but he's from India, and he had brown skin. So 1 year later, the court tried for a while to really say they meant white, and so they couldn't come up with it, but ultimately they said, well, Caucasian really means white, and that's as close as we got to a definition now. If we are a society governed by the rule of law, which I think we are and still are, then I think we have to ask ourselves, what is the law? And who makes the law? Now, Chief Justice John Marshall, who in Marbury versus Madison in 1803, really made the Supreme Court a lot more powerful than anyone had ever assumed would be. Not as powerful as today, but really set it up. And he says, I quote, "It is emphatically the province and duty of the judicial department to say what the law is." In the early 20th century, Chief Justice Charles Edmund Hughes, one of my new heroes, expressed the reality: we are under a constitution, but the constitution is what the judges said, a lot of other folks. Now remember, laws can be good or bad. Remember, slavery was legal in the United States. The Trail of Tears was legal. The Holocaust in Germany was legal in Germany. And Jesus Christ's crucifixion was legal under Roman law. Jim Crow and segregation became the law in these southern states. I want to begin with these criminal cases, and I think we'll just go there. This is the 1903 case. And now, this was the time period in which the court had not changed. And so, as long as the law was written neutrally, it was okay. It's a jury case. And no whites, no blacks at all were on the jury. And so this is like a cartoon showing whites on the jury. But the judges said in 1903 in Terrence v. Florida that it's not a denial of equal protection of the 14th Amendment because it doesn't say that blacks are excluded as long as you use neutral language. Neutral language is okay to do it. So now let's go to our 14th Amendment and look at the second sentence. That's important. We can forget about birthright citizenship, though it's obviously important these days. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of liberty, life, or property without due process of law, nor deny to any person within its jurisdiction equal protection of law. I like to say that Abraham Lincoln changed the Constitution. He says he didn't remember for anything was the Emancipation Proclamation. If he'd done anything important, I argue instead is he changed the actual Constitution. He took our mission statement, the Declaration of Independence, inserted into our rule of the Constitution. Those first 10 amendments, the first 10 relegated all power to the states. Congress shall not be able to do this. What each of the 13th, 14th, and 15th Amendment add is that Congress has the right to protect individuals in those states and all those things. So even that second sentence today, people have different views of what immunities and privileges and of what the process of equal protection of the laws mean. The lack of clarity meant that the Supreme Court and our court system must be involved to determine the meaning. Laws really don't matter if they're not enforced. And this is where we get to my new hero. And he didn't get credit. I discovered through the work. The court did not change with the Earl Warren, the court I grew up with, that we considered whether you loved or hated it, the court. It changed with this man who was a devout Baptist. His father had been an American Baptist missionary, corporate lawyer, but he believed in fairness. For the first time, he said, and this is where the evidence comes in, I want to see the evidence for that. Every single case that came from the South, in Florida, Supreme Court says this is the way it was, and it answers. So he said, I want to see the evidence. And it changed everything. This is when the ruling started doing that evidence matters. For the first case where the Supreme Court applies, in fact, the 14th Amendment is Chambers v. Florida. And it's really important. It says that through physical or psychological coercion, lack of representation, oppressions, intimidation, they violate the due process clause of that 14th Amendment. And it's extraordinarily important. It comes out of a robbery by Apollo Beach. And it's important for two other reasons. First of all, Hugo Black. It's his first real important decision where he is going to do it. And this is right after all the controversies, because Hugo Black was a member of that 1920s Klan that we were talking about, not in Florida, but in Alabama. So people had no idea how he was going to rule. And the other thing is that Thurgood Marshall was 32 years old, and it's his first case at the Supreme Court. And that's Marshall to the left, and that is the defendant there, who was held, trying to remember, about 15 hours, around about 40 people in all. Finally, after about 15 hours, killed 4, and just total harassment kind of thing. Very important case that makes so much difference. We're not going to spend a lot of time on the next one. Pollock v. Williams, a similar criminal justice case. What's most interesting to me is how stubborn you see Florida is. We don't have time to go through them all. But the year before, they had written on the same issue as Georgia says, no, you cannot really have indebtedness. You cannot have what we think of as leasing out. In this case, somebody had a man had taken $5 from another, promised to work for it and didn't, and then was, headed to work for the rest of his life, pretty much. You cannot do that. So it is a critical case that is a Florida case. And as I said, the most interesting thing is that it, despite the case having moved a similar case in Georgia, almost identical, Florida still tried to continue to do it and fought it off all the way. This is the case that I talked about earlier, and I know Mike has had Gilbert King, and you're so lucky to have heard from him. They just had him twice, but particularly on this case. It's amazing, Shepard v. Texas. This is a case that went 3 times to the Supreme Court. It will break your heart. It had, I don't know how much time, I think, since you've heard about it, I won't say too much about it, except what's really important. When it went to April 9, 1951, it was a procuring decision. That means everybody signed it. But Robert Jackson felt extraordinarily about this, and he and Felix Frankfurt wrote separate concurrent opinion, said it didn't go far enough, said they all agreed. It, quote, do not meet any civilized conception of due process of law. The case presents one of the best examples of one of the worst menaces to American justice. Now, at the very same time that Marshall is doing this case, he is doing the Briggs v. Elliott case that most people call Brown v. Board for reasons I have my 50-minute lecture to do, of why I always call it Brown v. Elliott / abbreviated slash Brown v. Board, and then I write it that way, is because of it. But this statement that he makes is on the board here, he's getting off a silver meter to argue Riggs v. Elliott in 1951 too. He says he's riding the train between there to come back for the Groveland boys, the Shepherd case, trying to save the last one who was on death row when they do trial. Sometimes I get awfully tired of trying to save the white man's soul. I love that. And I love when I teach the civil rights movement to point out that Thurgood Marshall understood what we don't often always understand. The civil rights movement is not just about black people. It's not to be had Black History Month. If we're able to continue to have Black History Month in my state and possibly yours, to celebrate certain people or events. Think about what it meant to kids like me who grew up in the age of segregation, white kids on the farm, and you're told that you're better than other people just because of your skin color. What kind of image is that do? That I hope we were moving away from. Well, the Groveland case also, and I won't go through all these details because I know students start crying, probably it's such a tragic case. But it was the impetus out of that came from NAACP's capital punishment, to do away with capital punishment. That led in 1973 the court saying that capital punishment was unconstitutional. Also said in 1976 Florida would get back on the boards. And also that in 5 minutes, okay. Well, what we going to do? I guess we won't talk about this as much as I would like to, but there's one thing that's important. This case wasn't well known at all. How important it was. It really shaped Thurgood Marshall's rest of his life. I think he was right. Maybe who he was, his home. And he later said, when we're talking about the law, I think it's important that his experience was a broken case, year away from him, that he would argue that laws do matter and can be good, not true only for legislating equality, because laws not only provide concrete benefits, they can even change the hearts of men, some men anyhow, good or evil. And you'll have to read about that. I'll tell you what we're going to do. We're going to go on some of the more important. The getting right case is important because it's a white man saying that he didn't had to defend himself, he could come under get a lot. But when they ruled, there's 2,000 people released from prison in Florida, and of those 2,000, about 90% were black, to show you how incarcerations were with black people. We just mentioned Property Florida. There's a great article about this by Mike Dillon on the judge who wrote this case, brought back in federal court. Florida v. Boston, when I say Thurgood Marshall, hardly ever, he won his cases before the Supreme Court, starting in that 1932 case. Hardly ever lost it. It's overwhelming. He gets on the court and he loses almost. He's on the losing side of the voting. This is one of those cases where they say that they can actually arrest somebody without probable cause just because they're sort of black on the bus, and the bus terminal on the bus at that time. So that's that. And of course, Rainer v. DeSantis, you know a lot about. But it was the Supreme Court let it stay at the level which was said that people had to pay to be able to, after Florida had been like only 1 or 4 states that didn't let felons who had served their time apply for it, and well, they could apply to be a political party. But then the legislature passed it to pay all these fines and fines. And that stayed, according to the 3 senators, led by Senator Sotomayor, it disenfranchised by the media or particularly poor minority voters. We're just going to skip. These are sort of important cases, but they have to do with the civil rights movement. The first one here is Florida State Legislative Committee. and that is where they have sued, in fact, to get the list to the NACT. It is so many states, and the Supreme Court already ruled they couldn't do that in Alabama, but Florida said, well, we've done it by committee. Those of you know probably a lot about the James Committee and then the State Legislative Board. It really started out as a two-way thing, but actually it was communist or not, and since they already in this was communist, the Miami head of the NACT was put in, was fined to go to prison, and the Supreme Court overturned that. This is, I think, and let's take just a few moments, and I'm sorry we're not going to get into all the other things that are so important. But, you know, we've had this crazy double standard for a long time, and I think to a certain extent still do, but are getting over it. And that is that this dualism to interracial sex and marriage, sex between a black man and a white woman, enraged some white Southerners beyond measure, and reports of such events, real or imagined, in the global case, imagined, sometimes led to lynchings and white massacres in Florida, and the rest of the South. The sex between a black woman and a white man, no one paid much attention to, whether it's Thomas Jefferson was strong through. A decade ago, after Brown, the Bridge v. Allen, 8 years after Douglas Mississippi, Supreme Court stepped gingerly into the last taboo of race, love and marriage. And it all begins when the court forwarded a Florida law prohibiting interracial marriage and cohabitation. I'm going to skip the quote from Loving, which ended it, but at the end of World War II, more than half the laws of the states had interracial sex and marriage laws. But by the time in the World War II, 16 states only had them in 1967. All Confederate states, including Florida, and 4 other states also were born in, sometime in the beat there. So the case that does this is McLaughlin v. Florida. And the case began when a suspicious minded property owner noticed that a black man named McLaughlin was spending a lot of time, including nights, with her white tenant named Connie Hoffman. She reported suspicious to the police, who investigated and arrested the couple for the Florida crime of living together interracially. They were convicted, they appealed, it went to the Supreme Court. It's very important. The Supreme Court said that it's an unconstitutional denial of equal protection to punish people solely because of their race. But the court did take pains to say it was not ruling on the validity of a law about interracial marriage. But McLaughlin Place is the one that sets the precedent for Loving, which comes 3 years later in 1967, and really discusses how all this worked to support, in fact, white supremacists. The other is Powell v. Cesare, and just briefly, there was a divorce between a white couple. The woman got custody, she remarried, she married as an African American, and they say that, then the husband goes back and says now he wants custody because it's not fair to the child because it was race. And this is the Macy's case. I think it's interesting because both of these cases, important Supreme Court, are coming out of Florida, that it really doesn't matter about the mixed marriage and children. And by 1984, that's sort of a thing of the past because America has accepted. But a very important case. How much time might that is? Okay, let's just say we'll get right here. I'm sorry to do that. And but I want to end though on a highlight. I'm going to try to say why I am excited about things. So let me just say that, to help you, my wife always told me, says, in conclusion, give you some hope. That Abraham Lincoln wrote in 1848, determined that the thing can and shall be done, and then we shall find a way. And I think in his 2 greatest speeches, the Gettysburg Address and the second one, Lincoln called on us future generations to complete the unfinished work. That means that work is ours. And as my friend, fellow South Carolina Jesse Jackson, reminded us in 1984 to keep hope alive. And hopefully we'll get some questions. I'm sorry we didn't have time. I've been fine if I just those 4 cases. And I thought I was going to start.
Thank you, Burton. I'm sure we got questions, and including some from my students. They're going to get a full crack at it tomorrow in the class. We're going to be drilling the 2 books they're reading. So, who would like to ask a question?
Mine is just so much a question. I think you and I are roughly the same age. I was in ROTC in '67 at the University of Florida. But you and I lived through a similar period.
Move down here. I can't hear.
I said, I don't have a question. You'll be one of your hopeful circles. But I think you and I grew up about the same time. And I was on the white side of all that. And never quite felt good about it at the time or since. But Gilbert King was a real shock to me because I always thought Florida was a bit above the rest of the South, and he kind of proved that we can't rely on that so much. As someone who lived there during the civil rights acts of '64, I all of a sudden found the world had changed to the good because prior to that time, even if a store in their money couldn't afford it because they didn't allow it. But anyway, I wanted to thank you for coming here. The only question I really have is certainly in the employment area, in school, the original idea of the Civil Rights Act was to protect minorities against majorities. And now we've turned it on its head. And it's, to me, it's unbelievable that it gets rid of the very reasons for the law to begin with has been really turned into bastardized. So, anyway, thank you for your insight.
There's a good question. I was actually going to get I need to get the mic. I can't hear with the mic's on, I guess. There is a great way, and I was going to go through and show how they have changed the 14th Amendment over and over again. Those cases went the other way, where you're using the but I debated the Federalist Society in Raleigh, North Carolina, before the affirmative action case was decided at the University of North Carolina, and it was quite an experience, as I was the only one there who was not a member of the Federalist Society. And they said they tried to get somebody from North Carolina, but fools sort of rush in and angels fit trees. So I'm going to tell the truth. And I think we've got to have civil discourse. I think we've got to respect other people's point of views in universities and everywhere. I mean, just because I don't believe it, I want to hear why other people do it. I know people in my mother's church feel very differently than I do, the church I grew up in. And they believe what they believe, and I respect that. But if we don't have dialogue, which is what I worry about, where we're going to get to. But I point out that in the first case, because they're using the argument of the textuality and originalism, the very first case is slaughterhouse. Everybody sees it as a bad case, but it's really not. It just says it's because it's not about white people. In fact, the judge says, because we know that the 14th Amendment was written for black people. See, the 15th is the only one that uses the name. But we know that the intention was the 13th, 14th, and 15th Amendment. And the person I was debating, which is also a great shock when I got there, because he's African American, I'm white. My parents didn't finish high school from 96 South Carolina. You would not like me to say that, but maybe Florida crackers, maybe? I don't know. But my roots are there. And so I am debating an African American who during the debate also admitted how affirmative action had got to where he was. But they admitted that this is what it was for. And yet, one of the reasons I have in the cases that changes is Citizens United. And that comes about because they passed a railroad act that says railroads are corporations. And they just sort of made that up in County Hall. And 85% of all cases under the 14th Amendment are about corporations. 85% had, so what it was about. But how that has been turned on its head, they voted the same way. And in affirmative action to argue the opposite of what it says, you're absolutely right. It just fascinates me that once again, we don't know that history. Even those of us historians, we don't know that history very well. The other thing that you're talking about, it was against the law for you to do things with black people. Part of those laws said that you could not do things together. So if you're obeying the law, then a good person, that's what you did. I mean, that's why I say the law really matters who makes the law. And that's what I always tell people. I love all the three branches of government. Each has a function. One of the things that's happening today is the legislative branch is not doing anything. They're just totally partisan and have been that way, and then the Supreme Court has taken up that role to a certain extent. And what matters there is when you vote, I want you to think about this. I would never tell anybody how to vote, but they are giving not only Supreme Court justices lifetime appointments. I mean, we've had justices who were in mental institutions, we have justices who are on deathbed. They don't have to retire. It's lifetime appointments. And people live a lot longer. And so it's broken that tradition. And even closer to home, those federal judges are lifetime appointments, not to mention even some of the important positions that are presidents appoint and things like that. So it matters who you vote for president. You need to think that, when you're looking for perfection, what is it going to mean in terms of the court who you vote for president, no matter what party?
Sir, on the first slide, you talked about the number of lynchings in Florida and mentioned second only to Mississippi. My understanding was on a per capita basis, Florida would actually be ranked number one. Can you confirm that?
Yeah, that's what I've heard.
That's absolutely correct.
That's what Bill King says too.
It's
Justice.
Yeah, it's really an easy problem. It's an easy answer, really.
And this, I had a PhD student, Terrence Finnegan, who did a study of lynching in Mississippi and South Carolina, and he says the same thing for South Carolina. Is per capita that South Carolina had more lynching. He also showed that almost all these lynchings were politically motivated, political lynchings, not for the whole kind of thing that happened with the local boards and the accusations of rape.
There's a case we're trying to get from the Supreme Court right now that I'm helping with that, where the issue is jury composition, which Florida has. You can be sent to jail with a 6-person jury. Most states don't have that. Florida rented that, and some other states rented that right at the time that you couldn't keep black people off the jury panel. And the sense is that the decision was made in part to make it easier to avoid that. And the research you've done on race in the South, the Supreme Court cases and the laws, have you seen anything that would support the tie between the time when black people were on jury and the time the state went to smaller jury size?
Yeah, the sad thing for me, and I always, sorry. Okay. The sad thing for me, and I used to say that every time I testified, I did not want to find that these laws were caused or related to race. I always went in with the law positive. They did not. And in my heart, I wanted to find that my people were not doing these kind of things to other people. I don't think I've ever done cases where I haven't found someone. I haven't studied this, but here's the rub about the importance of the law. When Roberts did away with basically Section 5, saying that Section 4 would apply of the Voting Rights Act. And there's a big discussion, I think I'm the first person who's pointed that out, that there's a limit that creates this doctrine of whole cloth. It's just the opposite of what he says it is by taking words out. I hope it was mistaken, but that's how it got there. He said, well, there'll always be Section 2, right? Well, to argue that, the whole idea is a chapter in the book on a battle of words, effect and purpose or intent. Well, that's where experts come in, because that's what historians are trained to do. The lawyers didn't know what they were doing for years. I remember the first time I got involved was 1980, when they called it the Vogel versus Vogel, because the Supreme Court had said it doesn't matter, the law has the effect to discriminate. If it wasn't intended to discriminate, it stands. And usually back then, it went back to Congress was a 25-year renewal. But these lawyers were panicking. What are we going to do? How do you, one of the, I think it's Burton, it might have been the New York Times, some wag says, what are they going to do? Go and dig up the stakeholders who wrote that law from the grave and say, did you intend for these laws to discriminate and keep, or is this just a byproduct of it? As long as it was mutually written and not saying it. So that's how I got involved, and that had helped. But recently, particularly Judge Alito has been after Section 2, and it's gone out, and it's hanging on by a thread right now at the Supreme Court. So it wouldn't matter if it did show it. I showed in the North Carolina felony disfranchisement case, the attorneys had said, well, you can't really do anything about intent because of when the law came. And they didn't know. I went back and studied it. The law was from the Vernon period. They brought it into North Carolina, and they, when they did it, they then adopted that law, which sounded like yes, but then they added for punishment, if a criminal will be punished, if someone had been publicly whipped, they could look, say, around 2,000 former enslaved and whip them so that they would not be eligible to vote. And that became a way of using it. And so we actually won that case. But guess what happened there? I was so proud of this, the work I did. They had an election. It was the state Supreme Court. And another party became the majority, and they just changed it back. It's just all of that. What used to be the law didn't matter showing the intent. So that's my big worry. I'd like to think it didn't happen that way. But now I'm more worried about that, in fact, even if it did, it won't matter if the court continues to deny that it matters if it's intent or not. So that's hard intent, very hard to prove. There were ways to do it. But in the Brodovich case that came out of Arizona, they just did not take the proof that was laid out the way under the Arlington Heights in 1977 insurance case told you how you proved intent. They just ignored it, even though it had been done in the case. So I don't know where we're going on there. That's why it matters that these justices are making the rulings that they are. And it has huge implications, huge implications. And I am very worried. I'm more worried, I think, about being able to tell the truth. I won't get into what's going on in my university, but it's very disturbing. People are afraid. High school teachers are afraid. It's not a good climate for democracy. Democracy is not static. Never has been. Their parents are going to try to show them we'll go forward, we'll go back. But, I think why Lincoln called it the last best hope is because we are in it. In a world where the rest of the world is moving so much more toward authoritarianism. I think we're in a crisis, and I only hope, once again, as it was in the Civil War Reconstruction period, is our Constitution and the rule of law, and judges applying that rule fairly. That didn't really answer your question, but,
Anyway, well, we're gonna follow along when we get Dr. Burton. We're gonna
go out to the foyer out there. I hope everybody can think about getting a book and ask some more questions out there.
I really apologize for not being here every time. Thank you. You're kind, gracious people. So you are Southerners. You're polite anyway, no matter how you say it.